Hello, my name is Fiona Jackson and I am a self-employed barrister at 33 Chancery Lane in London. And today I'm going to talk to you briefly about the new European Directive on freezing and confiscating the instrumentalities and proceeds of crime within the European Union. I'll split my presentation into 4 parts. Firstly, the long history of the European Union in tackling this important area of work. Secondly, the background into why this particular directive came into force. Thirdly, some key articles and provisions of the directive. And finally, its implementation thus far across the European Union. So let's turn firstly to look at the background. And for many years, the European Union has been concerned that criminals were becoming increasingly clever at moving and converting and transferring their proceeds of crime across the Union and beyond. That, of course, was an attempt to conceal them and prevent their recovery by member states. The European Union understood that international cooperation in this area is an important element of effective asset recovery, so that investigating and prosecuting authorities can help each other trace and recover criminal assets, prevent dissipation or disposal, and preserve them until such time as a confiscation order can be made and the assets recovered. For example, in 1990, all EU member states ratified a Council of Europe Convention requiring them to introduce laws to enable the confiscation of the proceeds of crime, including property used to commit a crime, and permitting the widest possible international cooperation in the investigation and confiscation of criminal assets. After the Treaty of Amsterdam, which introduced the power of the Council to legislate in this area, the Union has further and since developed a legal matrix to reduce differences in member states' approaches to the confiscating and recovering of criminal assets. For example, a Council framework decision in 2001 that was adopted on money laundering, the identification, freezing, tracing, seizing and confiscation of instrumentalities and the proceeds of crime requires member states to ensure that property corresponding to the value of proceeds of crime may be confiscated if the direct proceeds of crime cannot be seized. That, for example, is generally known as value confiscation. It also requires each member state to record the same priority to requests from other member states for assistance in identifying, tracing, freezing and seizing assets as it would apply for purely domestic proceedings. In addition, under a 2005 Council framework decision, member states must ensure that their own national laws make provision for the confiscation of proceeds of any crime punishable by a term of imprisonment of more than 1 year, and also introduce extended powers of confiscation in relation to terrorist offences and particular categories of organised serious crime, for example money laundering, human trafficking and the sexual exploitation of children. These extended powers enable national courts to infer, on the basis of specific facts, that assets belong to an individual convicted of terrorist or serious organised criminal activity, and that such assets must have been obtained as a result of previous criminal activity, even if they're not directly linked to the crime of which he or she has been convicted, and to order their confiscation. Another Council decision, a framework decision again, adopted in 2007, requires member states to establish national asset recovery offices to help trace and identify the proceeds of crime and other crime-related property which may be subject to a freezing, seizure or confiscation order. It provides a legal base for exchange of information and best practice. Moving now to the rationale for implementing this latest directive. The Council adopted in June 2010 a set of conclusions on confiscation and asset recovery that aimed at achieving a more effective and widespread confiscation of criminal assets. In March 2012, the Commission proposed that Member States have been slow in transporting and transposing the earlier framework decisions into national laws, and that the relevant provisions have often been implemented in an incomplete or incorrect way. It believed that further EU action was then needed because existing national, EU and international laws on asset confiscation remained undeveloped and underutilised. It questioned whether any member state confiscated a significant proportion of criminal assets and suggested that existing laws were therefore failing to achieve their aim. At this stage, it's worth pausing to note that the UN estimated in 2009 that proceeds of crime reached 1.5 trillion euros. By contrast, in early 2014, the EU calculated that less than 1% of those proceeds of crime were frozen or confiscated within its member states, and that most of this dirty money was laundered and channeled into the legal economy. The Commission therefore concluded that legal inadequacies and political and structural problems within member states could be so significant that they largely prevented the use of confiscation and asset recovery regimes against high-ranking, organised criminal individuals. It therefore wanted an increased level of harmonisation across the EU in order to establish in each member state a minimum level of protection from criminal infiltration in the legal economy through the acquisition of assets. And it added that it was widely recognised that a minimum level of harmonisation should exist in order to facilitate mutual recognition. The Commission believed that EU-wide action was justified because organised criminal groups, of course, operate across borders and often invest or conceal their criminal assets in several countries. So the EU would be better placed than member states individually to regulate freezing and confiscation of such assets. It's important to note, though, that this directive imposes and regulates only minimum rules and standards on the freezing and confiscation of the proceeds of crime. Within the European Union, of course, a directive is a legislative act that sets out a goal that all EU countries must achieve, but it's up to the individual member state to decide how to do that. Member states are free to include in their national law provisions which go further. The new EU directive on freezing and confiscation of instrumentalities and proceeds of crime in the European Union was adopted on the 3rd of April of 2014. It came into force in May 2014 across the European Union, and member states have until the 4th of October 2016 to adopt the necessary national provisions. For example, in English-speaking nations, Ireland has agreed to participate in this directive, but the United Kingdom, together with Denmark, are not taking part. They have opted out. I'm going to go on now to discuss in more detail some of the provisions of this directive. As set out in the preamble, it's hoped that the adoption of minimum rules will harmonise member states' freezing and cooperation regimes, thereby facilitating mutual trust and effective cross-border cooperation. The directive aims to make it easier for national authorities to confiscate and recover the profits and proceeds made by criminals from cross-border and particularly organised crime. The directive provides greater opportunity to confiscate the proceeds of crime where a defendant has, for example, absconded or fled from justice and the courts, and also if the defendant suffers from an illness which may prevent the proceedings from continuing in the normal way. It provides additionally for greater powers of extended confiscation, making confiscation easier when a judge is convinced that the property in question has been obtained through other crime. Confiscation may also extend to property transferred to third parties if the third party knew or ought to have known that the purpose of doing so was to avoid confiscation. For example, if the transfer or sale was for free or below market value. However, the rights of bona fide third parties are not to be prejudiced by this directive, although the directive does fail to define or give guidance as to what is a bona fide third party. Because of concerns raised by some EU member states, some safeguards have been expressly set out in the new directive, including the right to an effective remedy, to a fair trial, and for access to legal representation. Member states have also been directed to consider taking measures to allow confiscated property to be used in the public interest or for social purposes. The definitions of proceeds of crime, criminal offence, property, and instrumentalities are broad, and they expand the reach of the new directive within the European Union. For example, Article 2 is the definitions article, and it provides that proceeds means any economic advantage derived directly or indirectly from a criminal offence in any form of property, and including if later reinvested, transformed, converted or intermingled with other property acquired from legitimate sources. Property is said to mean property of any description, including legal documents or interests in instruments evidencing title or an interest in property. Instrumentalities is said to mean any property used or intended to be used in any manner, wholly or in part, to commit a criminal offence or offences. And criminal offence means any offence covered by the EU instruments listed in Article 3 of the new directive, which includes, amongst others, offences such as money laundering, corruption involving officials of the EU or of EU member states, corruption in the private sector, and organised crime. I'm going to turn now, finally, to looking briefly at the implementation of this directive throughout the European Union. Some observers have complained that throughout the negotiation process to get this directive passed by the European Union's Parliament, the directive was watered down in important aspects. In particular, for example, the draft directive had provided for confiscation, even without a criminal conviction, namely civil asset forfeiture proceedings. But that directive in particular is not found in the final version. So when the new European directive was adopted, the European Parliament and the Council called upon the Commission to analyse the feasibility and possible benefits of introducing further common rules on the confiscation of property deriving from activities of a criminal nature, and in addition civil asset forfeiture proceedings, harmonising those too across the European Union. Accordingly, Article 13 of this directive provides that the Commission, by the 4th of October of 2019, shall submit a report to the European Parliament and the Council, assessing the impact of existing national law on confiscation and asset recovery, accompanied, if necessary, with adequate proposals for reform. In that report, the Commission will also need to look into whether there's any need to revise the list of relevant criminal offences provided for by the Article 2. I said earlier that the UK and Denmark have opted out of this new directive. At the time of the draft directive, for example, the UK government considered that for the most part, the UK exceeded the requirements of the new draft directive. For example, United Kingdom law already allows for civil asset forfeiture proceedings and the confiscation of assets transferred to a third party. The government stated in this country at the time of considering the draft directive that our domestic legislation, for example, is robust, and it believed that it gave law enforcement agencies already extensive powers to identify, freeze, and confiscate the proceeds of all serious crime. In recent years, for example, it said that the United Kingdom per year has recovered or deprived criminals of over £1 billion worth of assets. It did, however, welcome the adoption of minimum standards across the European Union for the confiscation and recovery of proceeds derived from cross-border criminal activity. Looking elsewhere around the European Union, most nations have not yet taken steps to fully implement the directive into their national laws. For example, Ireland's Minister for the Department of Justice and Equality indicated on the 15th of January of this year, 2015, in a written answer that she did not anticipate implementation of this directive into the laws of Ireland until the fourth quarter of 2017, namely shortly before the deadline date for implementation across the European Union. But if this directive is properly implemented across the participating states of the European Union, and if the Commission's report under Article 13 makes further proposals in 2019 to plug ongoing gaps, then its aim to impose and harmonise minimum standards, at least in the area of confiscating and recovering criminal assets, will have been achieved. Thank you for listening to my presentation.